Hey, we're at 2 o'clock, so I'm going to try to keep everybody on schedule because I know as much as everybody wants to hang around today, we're going to get started. Hey, I know we got a little bit of a small crowd because got all kind of meetings going on, but I just came from appropriations. So, Representative, you'd open us in prayer and we'll get started.
If y'all bow with me, please. Dear kind and Heavenly Father, God, we thank you, Lord, for allowing us to live here in the greatest state in this United States of America, God. We thank you for the many blessings you rain down upon us, God. We ask your judgment, your discernment, and God, that we seek your will as we look at the issues and the matters of your people in Georgia. In God's name we pray, amen.
Thank you, sir. We're going to get right to it. The Speaker has tasked us to get a jump on the upcoming session and to get some knowledge so that we don't have to cover it during session. So I'm going to jump right in, and Mike, if you'll come up. Mike Pentecost is the administrator of the Subsequent Injury Trust Fund. First of all, tell us what the heck that is, and how we got here, and what's your plans to get rid of yourself.
All right, that sounded good. First of all, I'm Mike Pentecost. I'm with the Georgia Subsequent Injury Trust Fund. A lot of people don't know exactly what we do. We're probably one of the smallest.
Pull that mic toward you because you're not picking up. Table mic.
Is that better? Okay. We are one of the smaller agencies in the state. There's only 8 of us. But I'll give you a little rundown about history. First of all, it's an honor to be here with you. I appreciate it, Mr. Chairman and members of the committee, to be here. But last year when I came before you, I was asking for some legislation. We had a sunset date, which was set for the end of this year, which would be the end of this month. And we were trying to get it extended by 2 years to the end of 2025. And with you all's help, we were able to do that. And we passed it in the House and Senate, and it was signed. So I do appreciate the help I got from y'all. Today, I'm just here basically to give you a little bit of the history of SITF, a little bit about what we do and where we're going. Won't take but a few minutes, but a lot of people don't know what we are, and I think most of you up there I've seen before. You may know a little bit about us, but the Georgia Subsequent Injury Trust Fund, subsequent is just another word for secondary. And what this is, they're workers' comp claims. All of them are secondary injuries where an injured employee or someone with a prior impairment, there was an incentive to hire them, was what it was. In 1977, the Georgia General Assembly enacted legislation establishing the fund. It is designed to reduce the impact of large workers' comp claims in the event of a worker with disability, disease, injured on the job, or something that's aggravated by a pre-existing injury. It was an incentive for employers. And what was going on was, if you were an employer and you were going to hire somebody and you found out that they had a prior injury, maybe at their last place of employment, you might not be as open to hiring them because you're worried about that injury coming back up again. So the Subsequent Injury Trust Fund was put in place to where if that injury did come up again, their medical needs and their indemnity needs would be taken care of by the fund. And so it took a lot off of the employer at the time. It also helped keep workers' comp premiums down. So there was a thing about that. Now, the administration of the fund, we're overseen by a 5-member board of trustees. Those are appointed by the governor. They represent management, labor, the insurance industry, rehabilitation professionals, and the public at large. So quarterly, we meet with the board of trustees. We put everything out there for them to see, finances, reimbursement and settlement reports. They get to look at all that. And they put out, or they hire the administrator to see the day-to-day operations, and that's me. There are other three people that are part of our oversight, and that is we have 3 ex officio members, one from the Department of Insurance, one from the executive director from the State Board of Workers' Compensation, and one from the Department of Law. They're not voting members, but they are there in an advisory position. So if we have any questions about legal things or workers' comp things, we've got somebody to turn to. And that's another level of oversight for us. We have 2 sections that are mainly part of the Subsequent Trust Fund. That's reimbursements and settlements. And I got a lot of questions last year here was on settlements, and I'll talk about that in just a minute. But we reimburse medical insurance companies send us their medical records on a claimant, self-insurers, and that's the biggest part of most of our employees are dealing with is reimbursements. They go over it every month, and I'll show you that in just a minute. But a permanent impairment, which is what these people have to be the prerequisite for reimbursement from the fund. They had to have a pre-existing one. That is a disease or a disorder or injury, anything of that nature that is a hindrance to their employment. A lot of people ask us where our money comes from. That's always a big question. We are not appropriated. All of our money came from insurance companies and self-insurers through assessments that were paid yearly. Those assessments were decided by prior year's claims, and there was a percentage put into that. So we started accumulating funds in 1977 and to pay these claims. At one time, we got up to over 10,000 cases. It got overbearing, and that's when you guys decided to shut us down sometime back. And so we started trying to bring these cases down. Those cases were almost $1 billion of unfunded liability. So there was a lot of money out there. But we're currently down to around 540 cases. We've got a number of settlements that are going on this year and still working on it. But 500 is a lot more manageable than 10,000. We've got 80 employees. At one time, we had over 40. So as people have retired, we've just absorbed their work. We haven't hired anybody new. Nobody's had to be let go. It's just over the time we've been able to take care of it within the house. In 2006, when we realized that it was too many cases, I wasn't there then, but we decided to shut the fund down in 2006 and not accept any more cases. So the cases we have now are all pre-2006. We're just trying to work them out of the system. A lot of people call us a sunset agency because that's the way it was worded, that we're going to sunset in 2023. We're really not going to sunset. That's a little misleading. When we move to the Department of Insurance in 2 years, we're going to continue to work just like we are. We're just going to be under another agency. We're not going away. We can't go away until the last claim is paid. We felt that we had enough money to finish out the fund, and these benefits continue on. Now, when we talk about 2 sections, reimbursement and settlements, reimbursements, like I said, is our main component. We have claims analysts that are working every day as these reimbursement requests come in. As they come in, they can be a month's worth, they can be nearly a year's worth. We try to keep it to every 13 weeks. That's what we encourage, but they don't always do it. And what claims analysts do, when they get in maybe a stack of medical records on one of the claimants, they're asking for a reimbursement for maybe surgeries, prescriptions, doctor visits, all sort of things. And what they do is they go over each file line by line to make sure that everything that's in there applies to that injury. So in other words, if that injury was accepted in 1997 for a knee injury and you've got a bill in there that was for something he had done to his eye or his shoulder, that's going to get kicked out. That's disallowed. And we have to do that because I don't necessarily know that it's done on purpose, but stuff gets stuck in sometimes. So we try to be good stewards of the money and do what we're obligated to do. In settlements. Now, settlements is something we work on daily. We have one lady that's just strictly settlements. We send out settlement request letters trying to encourage settlement on these cases to get them off the books. When you had 10,000, you're down to 500, you know your easiest cases are gone. And now we're working on mostly all catastrophic cases. And some people want to settle and some don't, and you can't make anyone settle. A lot of people ask me, why come you don't push the settlement harder? Well, first of all, they're represented by an attorney. I can't push the claimant. I've got to go to the attorney, and the attorneys can only do so much. They're trying to settle them just like we are. They don't get paid until they settle. So, but we are making some headway. We have recently raised our cap. We had a cap of $300,000 on the medical end of things. We've removed that. We're looking at life expectancy now. We've removed several things that we're trying to make settlements a little easier and a little more, somebody to have a little more appetite for it. The future medical benefits, whenever we settle a case, most of our cases are settled through mediation. A few are not, but most of them are. We get together with the claimant's attorney, the employer, his attorney, and myself, and one other lady that's usually with me from our SITF, and we try to come to an understanding, of course, to settle them, because, we got to understand this person's hurt. A lot of times they're in pain, and their medical needs go on forever, and we want to make sure they're taken care of, because that's our obligation, is to take care of them. So whenever we settle a claim, if it's an indemnity, the indemnity part of it is supposed to take care of all of their medical needs from then on, if we all agree that amount will work. And we get 3 annuity quotes. It's paid through an annuity. Because if you pay some claimants all of it in lump sum, you would, they'd be in trouble in a little while. So they get a certain amount of money each year to pay for their medical bills. And that's probably the best way to do it. Sometimes we'll settle the indemnity part of a case and not the medical, or vice versa. But we are trying now to settle them together. When a settlement is finished, when everybody agrees, and we all put our signature on it, it's sent over to the State Board of Workers' Compensation for their approval, another level of oversight. They look at it, and 99% of the time they agree with it. Occasionally they'll find a little something, but it's usually correct. We've had a very good working relationship with the State Board of Workers' Comp, and their leadership's been great to get along with, and been very helpful. So we work together quite well. The end game. Somewhere down the line, the last claimant will be settled, or they'll die. Unfortunately, some cases, that's what ends them, is the person passes away. We've got people in their 40s, 50s, 60s, 70s, 80s, and 90s that are claimants. Most of them are 60s and 70s. We do have a few that pass away each year, but when that last person is over with, there will probably be money left over, and that money will go back to the insurers and self-insurers that paid it in. That money is obligated for that. So, that's just the way it's got to be. On a lighter note, that's pretty much what we do. I hope that helps you understand a little bit better what we do. I'm not asking for anything this year. I don't have any legislation. I'm very happy about that. So with y'all's help, we got it through last year. But just recently, we moved from downtown in the Marquee 2 building to the State building here at 270 Washington Street, right down the street. I walked up here, which was really nice. And so it's been a nice move. Still working out of boxes, however, but we'll get there. Just recently, a few weeks ago, we got together with our Board of Trustees, a person from the Department of Insurance, and started talking about our transition and the plans that will have to be done in 2 years from now when we move over to them. It will be a little different over there, I'm sure. Our funding would have to be separate, our budgeting separate, because our money is our money for that reason, those claimants only. They're appropriated, we're not. They use tax dollars, so it will probably have to be kept separate, and they're good with that. So I think everybody understands that we've got to do what's best for these claimants. So, and we're also in the process of early this year getting an actuarial report done, an outside actuarial report done, just so everybody can see that everything's on the up and up, and the insurance department will see that everything's good. So another level of oversight. That's pretty much what we do. I know to some people it's kind of boring, but
No, actually, since I've been on the committee, I don't know if we've had bills, mostly Sunset, but that's probably the most comprehensive overview that we've gotten, and I appreciate that. And number 26.
Me. Cameron?
Yep, Mr. Cameron, go ahead.
Yeah, thank you. When you receive a request for reimbursement and you validate it, do you negotiate a rate with a provider or do you pay bill charges?
No, at this point, we're paying it. We're just, the main thing we're looking for is make sure that everything's in that
Okay.
reimbursement is legitimate.
All right, thank you.
Is that Whip Park?
Thank you, Mr. Chairman. I had a few questions. Mr. Pentecost, thank you for, Administrator Pentecost, thank you for your presentation. You mentioned that the fund was originally established to minimize large worker comp claims. As the SITF is being kind of phased out, what mechanism exists to still minimize worker comp claims in lieu of the SITF?
Well, we really don't have any control over that. The cases we have are all we're ever going to have. They were stopped in 2006, and then we quit taking assessments in 2019. So there's no money coming in because we felt like we had enough money to last. So there's no cost to the state or anything. But those workers' comp claims that we have, there's nothing we can do with them except we're required to reimburse the medical and indemnity and settle them if we can. That's pretty much all we can do.
And just out of curiosity,
Yeah.
just because I'm curious, about how much in outstanding liabilities exist now. You mentioned about 10,000 cases existing with about $1 billion in outstanding liabilities. And when we're talking about liability, is this the state being liable for these?
There are a few
Claims or-
cases that are state. DOAS, we have about 84 of their cases, and they're like us. They're trying to settle them with us. They want to get rid of them just as much as we do. A total amount, I can get that information for you. I don't have it, but it's nowhere near.
What is your balance though now?
Money?
Yeah,
A little over 300 million.
okay,
Last question, Mr. Chairman. if I may.
And we earn interest too. So,
okay.
you know.
So in terms of the annuities and the annual payments, I'm assuming a $300 million budget should cover, and for some time, hopefully. Of course, given the catastrophic injuries of these final cases, maybe not so much. But in terms of, could you clarify or explain a little more in terms of the timeline as to the SITF and if that's going to be phased out or simply integrated into another department? Or
No, we're moving over to Department of Insurance. Y'all have made that real clear at the end of 2025. There's no choice there. They'll be running our division, but I mean, I guess you could say maybe we're going to be somewhat of a sub agency, and they'll be our bosses, which is it's fine with me because I'm planning on retiring. But the timeline for the cases is you can't really give a timeline because when you got people in their 40s and 50s and they just continue to refuse to settle, you've got to continue to pay them. We've got an obligation to that because of their medical bills and their injuries. But when we accepted those cases back before 2006, we're obligated from then on. You can ask somebody to settle all day long. Believe me, every piece of mail that goes out with our reimbursement request, whenever they reimburse, we send them back the money plus a copy of their reimbursement request, plus a letter always in there saying, are you interested in settlement? We send out settlement letters at random. We do wellness checks. So we do everything we can, but the timeline, it's almost impossible. I wish we could.
appreciate your service and leadership,
Sure.
Administrator Pentecost. Thank you.
Representative McLean.
Thank you, Mr. Chairman. I guess I'm not on the same line, but Mike, thank you very much for what you've been doing with them. I guess my only concern is you say the leftover monies will go back to the insurance company. I mean, that they paid in. I do understand, but I'm trying to figure out if some of those insurance companies may have went out of business and done everything
That
as
could be
well,
a problem. We
and
realize
all of that. So I'm just trying to figure out.
Yeah. I mean, the law says it goes, when it's all over with, it goes back to those who paid it in, That could be a problem. You're going to somebody's going to have to sit down and do a percentage-wise, but we're talking many, many years from now, 20 years or more, because some of those people are not going to ever settle. But yeah, the money does go back to those who paid it in because it was paid through assessments from insurance. It's not tax dollars.
So you said but it's going to be based on a percentage. I mean, I'm just,
Well,
when we're talking about 20 years,
Somebody's
that's
going to have to look, percentage of what, because some companies pay much more than others. Their assessments were based on prior year's history. There was a formula involved in that. So a little small insurance company didn't pay maybe as much as, somebody larger like Hartford or something. So yeah, that'll have to be looked at.
I'm just glad to know it's 20, 30 years. So
Yeah, I think the estimate that was given when the last actuarial report was done was like the last claimant might be around till 2042, something of that nature. So, but there's no way of knowing.
thank you.
All right, Mr. Pentecost, we appreciate it. Appreciate your service to our state, and thanks for coming.
Thank you.
The next issue, if Mr. Green, Mr. Tucker Green's going to come up and tell us about an issue that all of you should be familiar with, but we've got some newer members. In 2013, the Senate had a study committee to resolve this. It's now 2023. Every year we have worked on this. Another complicated issue, and when I spoke to Mr. Green earlier, I said, tell us like a fifth grader, since we'll go with an eighth grader, tell us what the issue is, and then how we're going to tackle it a little bit different this year. If y'all remember, Todd Jones carried a bill, and we passed it out of here. Pretty good. Remember the number. We also had Burchett had a bill, and we keep getting closer and closer. The House has done their job. We'll leave it at that. And then, so tell us what the issue is and what we can do to rectify it.
Well, thank you, Mr. Chairman. Committee, first and foremost, I am not Whip Burchett, so
Yeah.
he could not be here, but he asked if I would kind of paint the picture a little bit from industry standpoint of some of the things that are going on. I am Tucker Green. I represent several construction trades, and one most predominantly involved with this is the Conditioned Air Association of Georgia. But I just wanted to try and provide a little background on the issue that you kind of already noted that y'all have been working on for a number of years, and have passed a few different pieces of legislation out of the House that has not become law yet, but I know that's going to be something y'all continue to work on. But really the issue comes down to companies that are paying individuals on a W-2 versus a 1099 basis. And there's certainly, Whip Burchett and I talked this morning, there's nothing wrong with entities utilizing either method to compensate for service or whatever it may be. Certainly there's appropriate times to issue a 1099, and I'm sure many businesses do it for very valid reasons. Where the issue comes into play is when certain entities are using that to kind of go around paying their employees and paying taxes, issuing them a W-2, having the workers' comp payments and things of that nature, that they kind of are using the 1099 method to go around that, skirt the law, so to speak. And particularly when you have people who are working full-time or whatever it may be for a company or an entity. And not only does it cause issues for those individuals and not having them the worker protections and things of that nature, employee protections that they need, but you also run into disadvantages out there between competing companies. We see it a lot in our industry where you'll have a company that's paying all subcontractor crews and issuing them 1099s, not having the burden of the cost associated with having W-2 employees and providing them the benefits that most full-time employees would receive. So that's another area from the business standpoint where it comes into play is kind of it does establish a disadvantage for some companies that are competing against one another. So it's a complex issue. I understand that, and obviously something y'all have been working on, and not been able to get completely across the finish line. But I think it is certainly an issue that deserves to continue to be studied and try to be rectified in some regard. I mean, like you said, it's kind of a balancing act. There is a purpose behind 1099s in certain times where that is appropriate, but I think where we have to get some mechanisms in place to make sure that companies aren't using that as a tool to kind of avoid taking care of responsibilities they have and being in compliance with the law.
Thank you. A couple of years ago, till story, I was getting some items loaded in my truck and just making small talk with the employee who happened to have his hand pretty heavily bandaged up. And I just making small talk and said something about it was a holiday weekend coming up, and said about being off. He said, "No, I'm gonna be here Saturday." I said, "Well, at least you get time and a half." He said, "No, I'm salaried." And this was a guy loading the truck, and there's a 3 federal government in a case said that to be a 1099, they kind of gave not a strict guideline, but you had to be managing people, there were certain criteria, but this guy was at the bottom of the pecking order. And so he said, "No, I just get, $300 a week," whatever the number was, no matter how many hours I worked. And I said, "What about your injury?" He said, "That was my previous employer." I said, "Oh," I said, "You get hurt on the job?" He said, "Yeah." I said, "Well, at least," I said, "workers' comp took care of that." And he said, No. He said, "The employer told me that they would just take care of it if I would just, let them do it." And he said, but soon after the injury, they wouldn't let him get any rehab, any follow-up. And so 2 employers in a row in a small town and I'm just saying, if that's in a very small town, one guy, the issue is huge and multiplied. And there are some very high estimates of the tens, if not millions of dollars that the state and the workers' comp system is not receiving because people are not following the law. Whip Park.
Thank you, Mr. Chairman. Mr. Green, thank you for your presentation. I had a few questions. I was a co-sponsor for HB 389, a good bipartisan piece of legislation, which my understanding would really just even the playing field and codify the existing jurisprudence within this circuit as to how to determine a employee from an independent contractor. I know the law passed just last year and was signed by the governor in May of last year. Has there been any data or information in terms of how many cases the commissioner has investigated? Because I pulled the bill up. There were teeth in HB 389 in which the commissioner of the Department of Labor could assess fees if there were violations found based on the totality of circumstances. But is there any additional information or data as to whether or not, again, how many cases have been filed by the Department of Labor Commissioner, including any sort of impact on state revenue? That was an interesting piece for me just because in looking at other states who had implemented this, they saw an increase, tens to hundreds of millions of dollars in additional state revenue that we were otherwise losing. Could you speak to some of those points, please?
Unfortunately, I cannot. I'm not familiar with any data they have pulled since that did go into effect. That would probably be a question for DOL. So.
Thank you. And if I may, Mr. Commissioner, if we could perhaps get an update on some of that'd be helpful.
Okay.
Thank you, sir.
Anybody else? Do you know about the change we're going to try to do this year to get our brethren across the hall to?
I do not.
Okay.
We didn't cover
It's
that.
concerning the aggrieved party and some of y'all, if anybody in the audience cares to speak to this, y'all, I know y'all have a history. Does anybody want to speak out there? Well, if not, I think that exhausts our questions and comments. I appreciate everybody being here this afternoon. everybody have great holidays, and hopefully we won't see anybody until January. Thank y'all for coming. We're adjourned.